So hi, everyone. I'm Sarah Hartline. I'm an estate planning attorney with Margolis, Bloom, and D'Agostino. I've actually been with them for 10 years now, hard to believe, yeah, started right out of law school and have been there ever since. So, and I'm also the mother to two boys, 5 and 7 years old, and yes, so hopefully no calls from camp today. We had an eventful day yesterday with camp. I had my first, we lived in Somerville. Then when I had my second, we moved to Arlington, and now we are actually up on the North Shore to be closer to grandparents, but fortunately have been allowed to stay in the MOC universe. Then I'll pass it over to you, Samantha, my co-presenter, in terms of introducing yourself.
So I'm Samantha Owens, and I am an attorney, an estate planning attorney at Nixon Peabody in Boston. I've been doing this for almost about 5 years now. I have a 4-year-old son, Ellis, and a 10-month-old daughter, Margot, and we live in Arlington. Although when we first joined MOC, we did live in Cambridge. So we too have kind of made the move further north. Let's see. I think that's about it. I mainly do estate planning and estate administration. So yeah, happy to share my thoughts on estate planning today.
Great. All right. So yes, so I will start off just before getting into the specific documents, just to give sort of a broad overview of what is estate planning. So as I have here at the top, one part of estate planning that many people are familiar with is the idea of distribution of assets upon someone's death. Often, for example, people think of wills and also trust for that purpose, but estate planning is actually bigger than that, because it also is about appointing designated individuals in your life in terms of making decisions, healthcare, financial decisions in the event of, for example, a hospitalization or incapacity. And particularly, estate planning can be important for young families because of the fact that they're, in situations where there's minor children involved, there's also other planning that has to be done for them. So again, in that unlikely event that something were to happen to a child's parent or other caregiver, making sure that they're provided for, that there are trusted individuals in terms of taking care of them and managing any funds for them. So then we'll get into some more specific documents. I'll turn back to you, Samantha.
Yeah, so one of the many documents that we prepare, but I think two of the more, I guess, these are the two documents that you would use during lifetime. So we plan for during life and afterlife. So I'm going to talk about the during life documents, but the first one is our healthcare proxy, and this is really a document that governs, who makes healthcare decisions for you should something happen to you and you are incapacitated. So generally, this includes physical and mental health decisions. I'm sure you have filled one out when you go to the hospital. Say you gave birth in the hospital, you would fill out a healthcare proxy if you didn't already have one, stating who would be the person to make medical decisions for you and or your child should something happen to you. It also would include a medical directive, which gives any, it really states your wishes on any life-saving measures or no life-saving measures. A healthcare proxy generally tends to be pretty customizable. When we draft them kind of we throw everything at the wall. They're kind of boilerplate, but you can feel free to edit them to however you want them to be. So, you can make changes as you wish. So for example, one big one that you might be familiar with, a change that you would put into your healthcare proxy might be regarding organ donation should something happen to you. We try to cover all bases, but whatever you want to put in, we will try to make sure we could achieve that. One thing to note about healthcare proxies is that they go into effect when you are incapacitated as opposed to immediately upon signing. And the other thing to note is that we use healthcare proxies as an alternative to, as you can see in the slide, guardianship. So guardianship is a court-appointed situation where you would have an agent appointed on your behalf to make these healthcare decisions. And a guardianship really is kind of a costly and very public matter. And so it really is helpful to have a healthcare proxy in place in order to avoid that happening. We can go to the next slide. And the next slide is the durable power of attorney, which again is a document that we use during your lifetime. So your durable power of attorney names an agent who can make financial decisions on your behalf. So they have access to bank accounts, investment accounts. Depending on what your document says, they may be able to sell real estate on your behalf, do business dealings on your behalf, really kind of any financial matter that's explicitly outlined in the document. They generally give broad authority, but we do like to try and include, everything, so that your agent can do whatever needs to be done should something happen to you. One thing to note is that there are two different kinds of durable power of attorneys. The first is a springing durable power of attorney. Those do not become effective until the person who is making it, the principal, is deemed incapacitated. So usually that's done by a doctor certifying that the principal no longer can make decisions on their behalf. The upside is that nobody can make decisions for you without your knowledge while you are with it. But the downside is that should something happen to you and you are incapacitated, it can really hold up the process of making financial decisions and getting access to any financial accounts until the doctor or a doctor makes that decision. The second durable power of attorney is the actual durable power of attorney, which is effective when you sign the document, but it's designed only to be used if you are incapacitated. So we generally use those when a person is naming an agent who they have a long-standing relationship with. So a spouse, a parent, a sibling, a really, really good friend, somebody that you can trust. And again, the alternative here for the reason why we use a durable power of attorney is to avoid what we call a conservatorship, which is similar to a guardianship, but you can think of it as a guardian of your finances. So there's a guardian of the person and guardian of the finances. And a conservatorship is very, very involved. It can be very costly to a family who is trying to care for their loved one who no longer can make the right financial decisions for themselves. And the most effective way and the most efficient way to make sure that you don't get caught up in a conservatorship is to have a durable power of attorney.
Great. And Samantha, a few questions. I don't know if can you see them from your end, or do you want me to read them?
No, I can't see them.
Okay, great. So I'll read them. So first question, it said, obviously incapacitation can be unexpected. What happens if you're in a car accident or become sick without a healthcare proxy or power of attorney in place?
So, the doctor would look to your next of kin. I mean, if you are married, your spouse would generally be able to make decisions for you, a parent or family member. But outside of that, a close friend, you know, you think about people who aren't married, who don't have these documents in place. It really does become a difficult situation, particularly at the hospital, if you don't have, or if you weren't given legal authorization to make medical decisions for someone else.
Right, and so I think a similar question was, you know, how are these documents different from what decisions someone can make for another as a legal spouse or parent? So I think you sort of touched on that in terms of, you know, in some situations that for like the healthcare proxy, that they might turn to the next of kin. Although my experience and yours might be different, Samantha, is that for the power of attorney, even, you know, being a spouse would not be sufficient to get that information from like a bank, for example, or to talk to an employer.
Absolutely. I think just to nail down on that question, these documents really give some specificity as to what these agents can or cannot do. And so, you know, your spouse, your child really might not be able, as Sarah said, be able to go to the bank and just say, hey, I'm so-and-so's daughter. I need access to her bank account without some sort of legal documentation. And the banks, you know, they wouldn't accept that. They would tell you, you need to go to a court and get a legal document.
Right. Yeah. And unfortunately, a lot of the work often at our firm is that situation where a spouse, particularly if it's a younger married couple, if one of the spouses is in an accident and the other spouse is trying to, you know, get information, make decisions in terms of financial assets, or understand even, you know, the details of the employer's healthcare insurance. Like those are all things where, unfortunately, in that situation, that a court process might be needed.
Right.
Okay, so I think some of these are, I think they're more related to other topics that are coming up. And someone said, oh, thanks. This is helpful as my mom is running into this with my alive but very sick dad's bank accounts. They've been married for almost 50 years, so it's been very unexpected. So yes, unfortunately, even being together, married for 50 years, could still require going to court just to get access to that information. So I'll hold off on some of the other questions just because I think they'll come up when we talk about wills and trusts. So let me go to the next slide. Okay, so I'm going to talk, just give a little bit of an overview in terms of last will and testament. So the will is probably one of the more common known estate planning documents, and it has actually a few different roles. So first, it designates how property should be divided and distributed, both tangible personal property, which could be things like furniture or jewelry, and then the residue, which would be any sorts of bank accounts or real estate. The important thing here, though, is in terms of distributing your property, is that the will is only, it only controls what's called your probate estate. So when you say probate estate, it's those assets or real estate that's in your individual name, and there's no joint owner or beneficiary designation. So if, for example, you own property jointly with a spouse and one spouse is to pass, the other spouse will, as long as that is held as joint with rights of survivorship, that other spouse automatically inherits that account. It does not go through probate, and the will really has no role in designating what should happen to that account, that property, because it's owned jointly with rights of survivorship. You can also join bank account, own bank accounts and investment accounts jointly with rights of survivorship. So again, some situations, if you have a married couple, for example, and everything is owned jointly with rights of survivorship, there may be no need to go through probate, and the will really doesn't have any not really any importance for that at that stage when that first spouse passes. However, where an individual passes away in Massachusetts and they do have assets that are in their individual name, so say, for example, I have a bank account and it's just in the name of Sarah Hartline. It's not jointly owned. It doesn't have a beneficiary designation. That is an account that is a probate asset. And so that's an account where somebody, if I were to pass, somebody has to go to court, has to file my will. If I have a will, if I don't have a will, still has to file paperwork in order to have the court determine who my next of kin are and who would take under the law of Massachusetts, because there is no will. So that whole process is called the probate process. And I have a little bit more about that on the next slide. But that's just an important thing to remember, because sometimes people will put things in their will in terms of how assets are to be distributed. But if they do have different beneficiary designations on it, the will is not going to override that. The other two important things that the will does is that it puts someone in charge of your estate. So of course, someone has to be doing all of that in terms of marshaling the assets, going to the banks, filing paperwork with the court, distributing assets pursuant to the terms of the will, or pursuant to the terms of Massachusetts intestacy law. And so that's often called, people often know that as the executor, although in Massachusetts it's called, technically called the personal representative. The third important thing that the will does is that it names you can nominate in the will a guardian for minor children or for incapacitated family members. So that's really important in terms of for young families, is to include in that will. Again, if there are two parents and one parent is to pass, the other parent is still, the natural guardian still has automatic custody and decision-making authority for the minor children. But in that unlikely event where either both parents, or if it's a single parent, if that single parent is to pass, it's very important to have that guardianship nomination in the will. So I'm going to jump back to the questions because I'm happy to see lots of questions. So making sure that I answer. So can you name multiple people? I'll turn this one to you, Samantha. Can you name multiple people as healthcare proxy or power of attorney? One of the concerns is when an accident happens, there's a likelihood my spouse would also be affected. So it would be good to have a backup.
Yes, of course. You can name as many successor or alternate agents as you'd like. We generally like to have you name a primary agent and then a successor or two. Some people like to have more than one person serving at one time, with the thought that they will make decisions together. They need to make unanimous decisions. I'm just thinking the healthcare proxy. We also will have people who want their proxy, say your spouse is incapacitated as well, the successor to consult with other family members before making decisions. So yeah, there is a lot of flexibility there, and availability of more than one person to help make those decisions.
Okay, great. And then someone asked, can you name a guardian based outside of the United States? And if so, can the guardian take the child out of the country in the case of death of both parents? So, so you can name a guardian outside of the United States. When you're naming a guardian, you're naming a specific person, and that, we have some situations where people name somebody that is in the United States now, and they may move in the future, and vice versa. They could name somebody that's outside the country that later moves to the United States. So the guardianship, there's not a restriction on whether that you can, but that the person has to be, that you're naming as guardian, has to reside inside the United States. That said, there's obviously a lot of additional steps where, for example, and without knowing the details, for example, if the children are going to a country where, there's just sort of administrative hoops to jump through in terms of moving that child from the United States to a different country as their new residence. So one thing that I often recommend is that we, in those situations where somebody wants to name the guardian who's somebody who's living outside the United States, they will often appoint an emergency or a temporary guardian who is in the United States, who's somebody who is someone who can take on that role immediately. And then even if the plan is for eventually for someone outside of the United States to become the permanent guardian, that can help with just the process before that child or children can actually move, and those arrangements, appropriate arrangements can be made if, if possible to do so. I don't know if you have any other thoughts on that, Samantha?
No, that's exactly what we would do too. We would have the family appoint a temporary guardian who, somebody who's a neighbor or somebody, nearby, so that there's not too much disruption. Obviously, a lot of this also depends on the fact that when you appoint a guardian, you're not actually appointing, you're kind of making a recommendation, and a court actually has to appoint the guardian. And so, we try to make that process as smooth as possible with all of that in mind.
Right, that's a really good point. So it is a nomination, and the nomination does have priority. But I have had people ask before in terms of, if there is reasons why a court might not appoint someone that's nominated, and certainly if there were certain extenuating circumstances that made the person otherwise unsuitable to serve in the role of guardian, ultimately the court could decide that that person's not appropriate. So it has a lot of weight in terms of your nomination, but ultimately it's not that it's set in stone. Another thing that I often tell people is, one issue that comes up a lot is that people, parents that have young children now, their own parents are often very involved, but they have concerns about, naming their parents as guardians just because of, in 10 years, they're concerned that, their parents are aging and getting older. And so even though they might be able to, be a good person right now, in 10 years, maybe they're not the right person in terms of serving in that role. And so you have a few options. I mean, one thing you can do is, as Samantha mentioned, with the healthcare proxy and power of attorney, you can certainly have alternates. And one thing that I've had clients do is, like, if they've named their parents as the primary, they've made sure to have alternates, and then they've also included like a supplemental letter or a memorandum, just making it clear that, that they, would love to have their parents serve in that role, but if their parents feel like, due to their health or their just ability to serve as guardians, they're just not really able to do so, that they could, that you have these other backups that you would also be, comfortable serving in that role. So it's a way of sort of, both putting it into, legally having those different backups, but also having supplemental memorandums or letters so that the people know that you're also comfortable with these other people serving if they kind of don't feel up for the job. I don't know if, do you do something similar, Samantha, in terms of supplemental letters or memorandums with your documents?
Yeah. And I think one thing to also keep in mind is that, like, we call it a last will and testament, but they can be updated. It's not like you write one and that's it. You can never change it. It can always be changed. And so, yes, we do that either through side memos, whether it be for tangible assets or for things like, making express wishes about guardianship.
Right. Yeah. So that can be helpful. It can be helpful to have both, on the one hand, you have the legal documents, and then on the other hand, having other documents which might not be, necessarily legally binding, but just serve as guidance for these people, because obviously in most cases, they're people that, you trust to, carry out your wishes, the best that they can. So, so it's helpful to have both. And that's often the case for our clients, especially young families. So let me just make sure I've a few other questions. So there's a question about life insurance, which I think I will talk about that in a minute. Because I'm going to talk about, so the will, as I had mentioned, so sort of the functions of the will and the fact that that's all part of that, as I said, that probate process. So those assets go through, I don't know if my, go through that court process. And there's similar to guardianship conservatorship, with probate, there's this, first of all, it's a public process. So these are all, these documents are all public and accessible online. It can be costly and time consuming, especially in situations where if something happens suddenly, for example, I've seen situations where there's not really any estate plan, some things happen suddenly, and there's just a need to access funds for example, for minor children. So that can be a problem when you have to still go through probate in order to get access to funds or in order to sell real estate, things that the family's trying to do and take care of quickly, while also, of course, handling, taking on, for example, guardianship of minor children. So, so that's why it is important in terms of making sure, first of all, in terms of making sure that your beneficiary designations are up to date. And that's something that when if you worked with an estate planning attorney, that they should do as part of the process to say, with your accounts and, if you have life insurance, that those beneficiary designations or titling is up to date. One thing, because in a lot of cases, though, just doing a joint ownership or doing a beneficiary designation is not really an option. And of course, in the event where you have two parents and they jointly own accounts, if something were to happen to both of them, that obviously does not prevent the probate issue. So based on all of that, that's one of the reasons why people will often turn to doing a trust. So I have here why use a revocable trust. And one of the first reasons is avoiding probate. Probably, I don't think it's probably the most important, but it is one of the reasons why people use revocable trusts. You can basically, so those assets, instead of having them in individual names or joint names, they can be put retitled into the name of a trust, and then the trust itself will provide those instructions to say, if something were to happen to me, this is how the assets should be distributed, or they should continue to be held for benefit of children, and all of that, because it's in the trust, means that it avoids that court probate process. For me, though, I think probably the more important benefit of doing a trust for young families is that ability to have a trustee who can manage assets for, whether it's minor and or disabled children. The trustee, it sets up this, basically sets up this system where instead of having a child who at 18, for example, inherits this large amount of funds into their name directly. So with life insurance, for example, if you had your spouse as the primary beneficiary and you had, one or more children as alternate, you might not really want that child to inherit that large amount of funds individually into their name if they were, for example, 18. And so one of the advantages of the trust is that you can name the trust as a beneficiary on the life insurance. The life insurance then pays out to that trustee, who would be, a trusted family member or friend to manage the funds for the benefit of the child or the children up until certain ages. So you can put in those terms that the child would be able to, at a certain age, 25 or 30 or 35, at that point, certain amount of money would be distributed to them. Up until that time, it's up to the trustee to make decisions on how those funds should be used. So I think for me that, sort of having that additional management of funds for children, I think is important, but there's also the probate avoidance. And then I think the other big reason in terms of trust is what we're going to talk about next, which is estate taxes, which I'll turn over to Samantha. But I think just in terms of answering that question, so let me just see where the question was. So one, yeah. So how does life insurance factor in? So yes. So with life insurance, again, you can have beneficiary designations, but you still may want to have a trust if there's minor children involved, so that upon both spouses passing, the life insurance can pay into that revocable trust for the benefit of children. And then the second question was, what does it take to set up a trust? I assume it requires hiring an attorney. Yes, I mean, I think generally speaking, Samantha, you can, I think, agree that generally speaking, you wouldn't want to try to set up a trust on your own.
No.
No, yeah, no, I think that. So I think, yeah, I think generally speaking, it would be something to, yeah, to talk to an attorney about. And a lot of the times, what I tell people is that, you know, it's good to just to talk through with an attorney these things to see, you know, everyone obviously has different levels of, you know, assets and ability to, you know, spend money in terms of estate planning, but just doing an initial consultation with an attorney can be helpful just to see, you know, whether a trust would be appropriate, if there's other ways of, you know, handling assets in terms of distributing them, and just sort of answering those initial questions for you. And then the third question before I go to the tax planning. So the third question is, who can serve as an independent trustee? So I have here independent trustee or family member. That kind of gets into a little bit more of the more complicated, because the reasons why you might want to have an independent, so you could have, so in many situations people do have a family member as a trustee or a friend as a trustee. An independent trustee, that is in certain types of trusts, if you wanted to have certain protections or sort of certain tax planning benefits, that might require having what's called a independent trustee, who's somebody who's not a family member. So it's a little bit probably outside the scope of this presentation, but just flagging that you know, in certain situations, depending on how the trust is set up, that might be something that's required. But in many situations, clients will just have a family member or friend as the trustee. Okay, so I'll go on to estate tax planning to Samantha. Yeah.
The fun part.
Yeah.
The fun part. I don't know, maybe I'm sure nobody thinks this is actually fun, right? But it is a really big accomplishment when you do sign those documents. So really encourage people I'm really happy that people were so excited to talk about this, because it is something that's so important. So the tax planning portion, really, it doesn't affect everyone. It will affect those who, so in Massachusetts, you might have heard that last year, the Commonwealth raised what is called the estate tax exemption from $1 million to $2 million. And basically what that means is each individual person who dies living within the Commonwealth of Massachusetts, or who dies owning property in the Commonwealth, has a $2 million exemption.
Oh, I think you just went
meaning that if you die with an estate valued less than, oh no.
Is your sound going off?
Yeah, give me 1 second. Can you still hear me?
I can hear you.
Okay. I'll
let you know if it goes out again, and I can always jump in and help.
Okay. Is my video there? Because I can't see you now.
I think that it's just the slide. This is where my my lack of technical skill. I think right now everyone sees the slides.
Okay.
Yes. So,
all right.
But yeah, go ahead. I can hear you now. So I'll let you know if the sound goes out again.
Okay. Sorry about that, guys. So I'll just to reiterate. So if you die with an estate that is valued less than $2 million, then there is no estate tax owed. If you die with an estate that's valued over $2 million, every dollar above that $2 million exemption is taxed at a progressive rate up to 16%. So one thing to keep in mind is that $2 million sounds like a lot of money. It is a lot of money, but $2 million can quickly add up. So that $2 million is made up of any real property or any real property that you own, real estate. So, house, car, or it also includes car, investments, bank accounts, life insurance proceeds, any sort of stocks or annuities. It would include retirement accounts, and it also includes any taxable gifts that you would have made over your lifetime. And a taxable gift is a gift made over the gift tax threshold. So, a lot of times people will talk about, my parents want to give me or give my kids a gift, and there's a certain amount of money that can be given during the course of a year that is non-taxable. Anything over that amount is taxable, and you would file a gift tax return, and the IRS would, keep track of that. And so those taxable gifts are also included in that $2 million. So one thing to keep in mind, I'm already ignoring the federal tax exemption, which is $13 million or $13.61 million, because that is an exorbitant amount of money. Very few people actually meet the threshold for an estate tax payment on the federal level. But here in Massachusetts, like I said, it is pretty easy to get to that $2 million. If you own a house in this area. So as Sarah's slide says here, a married couple can use estate tax planning here in Massachusetts to minimize estate taxes on the state level and the federal level. And so in order to do that, we use what we call marital planning or marital deduction planning to defer the payment of estate tax or to avoid it entirely. And we do that while allowing assets to appreciate and grow, for future generations. And the ways in which we do that is probably a little bit beyond the scope of this conversation, but generally we use revocable trusts to set up this marital planning. We draft your entire estate plan to take into account this tax planning so that we minimize any sort of taxes that need to be paid either at your death or your spouse's death if you have one. So gifting to reduce your estate taxes. So as I was talking about before, taxable gifts, you can use gifting to non-taxable entities to reduce any estate taxes. So, making gifts to any charitable beneficiaries. So we all know of nonprofits being 501c3s, churches, things of that nature. When you make large donations or large gifts to those entities, those are not taxable, and that money leaves your estate and will not be taxed at your death. So that was a very broad overview of estate tax planning in Massachusetts, but happy to answer more questions. And sorry for the technical glitch.
No, not a problem, man. I think my screen's still up, I think, right? You're still seeing me, Steve. Okay. Yeah. So yes, estate tax planning, yes. So definitely, yeah, it's complicated. But as you said, for people that are interested in estate tax planning, because as you said, they, a lot of times, for example, life insurance and other assets does add up. That is definitely something that one of the functions that the trust can do is that they can help with estate tax planning. So, so yes, so then just, I know I want to make sure I'm at the end for, I know there's some more questions coming in, but yeah, so in terms of trusts and accounts, this is just a reminder in terms of, first, in terms of with trust and retirement accounts, that that this is an area that's a bit tricky and something that, assuming that you do set up a trust with an attorney, that they would walk you through. But because retirement accounts do have required minimum distributions and other specific rules and tax laws that apply to them, you have to be careful about naming a trust as a beneficiary on a retirement account. And then second, just wanted to flag special needs trusts. So we've been talking a lot about trusts for minors, but there's also a large part of our practice is special needs planning. So even past the age of 18, when you have a child or another family member or individual who is a beneficiary of your estate plan, but they have special needs, a special needs trust is often the appropriate type of trust to set up, so that both that those funds can be managed for the beneficiary, but also that it doesn't interfere with their access to certain public benefits. So that's also something just to be aware of. So I think I had it that you were going to just maybe give a wrap up. Samantha, I don't know if any other thoughts on any of these to add.
No. So yeah, these would be the top 5 documents that we recommend that, after having talked through your specific financial situation, family situation, these would typically be the 5 most common documents that we would recommend. Revocable trust is depending on your financial situation. There are different types of trusts that we might recommend. But yeah, I'm happy to answer any more questions about any of these documents, and it's been really great. The questions have been great. So yeah.
Great. All right. So I will go back to the questions. And actually, I'm going to probably just take down I don't think I'm really doing this very well anyways, in terms of the screen share. Perfect. All right. So going back to the questions. So this is a good question. So somebody asked, does a revocable trust replace the need of a will? So often the revocable trust really, it does. That said, because if everything is designated, so if your life insurance is designated to go to the trust and other assets are retitled in the trust, the will might actually not have any sort of a need for the will. We typically still do recommend that you have it because it has, so it has other functions. So for example, the guardianship nomination would be in the will, and also because there could be other like accounts, like often when we're doing estate administration, there is like a random bank account or a random stock that just never made it over to the trust. And so the will acts as a catch-all. So it's often, they're called pour-over wills, because the will just say any assets that are, so for example, for me, it would say like any assets that are in Sarah Hartline's name individually, part of her probate estate, are left to, for example, the Sarah Hartline Trust. So it's, there's a possibility that you can minimize or avoid the need for probate, but it's still there in case it's needed. And then so let's see some other questions. So how often do we update these documents? Samantha, I'll let you take that one, what you recommend.
Oh yeah, I mean, I would recommend taking a look at your documents probably like every 5 years, 3 to 5 years. Big life changes happen, especially at this time in our lives. I mean, we just have to be honest about the fact that if you still have living parents, they're getting older. Your grandparents are getting older if they're still living. We at this point in time is when we start to see more big transfers of money. And when that happens, we typically encourage people to come back in so that we can look at what your trust documents say and make sure that any large sums of money or real estate is going to do what you want it to do when you're no longer here. So yeah, I would say between 3 to 5 years, and or anytime, a really big life event happens. Yeah.
Okay, great. And then somebody else asked, where are these documents stored? How would I know if my parents have created these, for example? So that's also a good question. So in terms of with my clients, like once we've actually met to sign the documents, so we keep, so our firm, we typically will keep the original will and power of attorney, just because those documents are often the ones that are it's really important to have an original, and so we do offer to hold those in our office safe. I know, other attorneys, some do, some don't, but and then also we keep scanned copies of everything. So the other documents like trust or healthcare proxies, we have scanned copies of those. And then what I usually tell people is that I usually don't recommend sharing all of the documents with like family and friends, just because for one thing, as Samantha mentioned, things can change. And so I think it can be very awkward if you name somebody as a guardian and then you spend a vacation with them and decide, actually, we don't want you as our guardian anymore. I actually don't think that you'd be a great person to do that. So I think just it's nice I don't love to have like those documents all out there. And so what I recommend is just to tell those people, if you, for example, if they were working with me, to say, here's Sarah Hartline's firm and her contact information. If something happens, if there's an emergency, contact her. Her firm has all the information. They can walk you through the next steps. And then you have electronic copies of your documents. And then you also have any of those, original documents if the firm or attorney is not holding those as well. I don't know if you have any other thoughts on that.
Yeah, so I'm actually sitting down with my in-laws next week to go through their documents, which is like, ugh. Oh no.
I can still hear you.
Oh, okay. I don't know what happened. Yeah, so you asked, how would you know if your parents had done this planning? You wouldn't know unless they tell you. And so it's one of those hard conversations to have. I had to have the conversation with my own mom too, and doing this, for work, it was still really awkward to talk to her about. But yeah, you wouldn't know unless they tell you or you ask. The other thing that I was going to say is that if your firm does not keep originals, we generally do not recommend that you keep particularly your will in a safety deposit box. Safety deposit boxes can be very hard to access once you pass away, because they fall into kind of like that probate property, right? Where if it's not a joint, if it's not jointly held. So I've had plenty of times where I've had to file probate paperwork just to get access to a safe deposit box so that we could get to a will. And so you don't want that.
Yes, yeah. So not a great, safe place in your, I mean, even I mean, I think, even if it's in, like I said, you also have, hopefully, like the attorney's office has a copy too. So that is like a backup. But yeah, I agree. Not the safe deposit box is not a good approach, although it's counterintuitive.
It is.
Someone just commented that my parents had an estate plan. They didn't need it from a wealth assets perspective, but it simplified the whole post-death process when my dad died at 56. So a helpful comment. And then I have someone that asked, can a trustee be a family member who is not a US resident, who doesn't live in the United States? So the answer to that is a little complicated, but what I typically recommend is that so one of the issues here is, of course, you could name somebody that's living in the United States and then they could move, or vice versa. However, generally speaking, if somebody is not residing in the United States, it can be difficult for them to serve as a trustee because there are both because financial institutions here will often want the trustee, the trust, to have a U.S. Mailing address, like residential address. So there's different laws that were passed that are, I think the goal is, there's sort of money laundering or different types of moving money around outside the country. And so they have a lot of really strict laws in terms of these trusts having a US president. Oh, sorry, US president. So often I do recommend that, and at least one of the trustees is residing. The citizenship is not important as much as the residence. But there are some workarounds for that. So for example, you could have like one trustee that is outside the United States, another trustee that's in the United States, and there's various ways to work around it if that's important to do. So that's something that definitely an attorney could talk through with you. And then let's see, I probably have time for 2 more questions. So I think one is, presumably if you move from one state to another within the United States, these documents should be reviewed and potentially updated. Does the state of residence at death determine which state's laws govern state taxes and other associated topics? So yes. So it's all based on where you are a resident. I've actually had interesting cases where there's been a question of residency where people have, live in New York part of the year, live in Massachusetts part of the year, and go back and forth. But yes, ultimately, where it's determined that you are a resident would determine whether, in terms of things like estate taxes and the laws that would govern. But as this person had mentioned, yes, that's generally, it doesn't mean that all of your estate planning documents just become void once you move. It's just that it makes sense to have an attorney review them because there might be certain language that is recommended to include or things to change because of that state's specific laws.
Yep.
Yeah, and then I think, so the last question I think is just, there was a few questions just in terms of like budgeting, cost, fees. Samantha and I had actually talked about this right before the presentation because I know that those are important questions. However, we also just didn't really feel comfortable like putting numbers out there because we, each of our firms have different ways in terms of how we work, and also so much of it depends on your individual situation. And I just don't like to, presume certain things in terms of documents that you need or don't need. So I would say either of us, we will put our contact information back up on the screen. Feel free to reach out to either of us, and like whether it's by email or call, we can give you like an idea as like what you're asking for in terms of estimated costs or fees based on your situation. But yeah, there's really, as you can see, there's just really a broad range. There's people that are thinking about things like estate tax planning, people that probably look at that slide and they, laugh at that. That's, really just not something that they're, thinking about this at this stage in their lives. And that's, so yeah, so I think it's just really individual. And so we are happy to talk to people one-on-one to give them more, or advice if maybe we're not the right person to be helping them, to point them in the right direction of someone that would be a good fit for them. Okay.
Thanks for saying that.
Yeah, so I will close it out. Yeah, I guess I will put that, yeah, I guess I'll just put that information up again. Let me see if I can figure out how to do that back on here. Is that showing up? Perfect. Yep. Yes. All right. So that's the contact information. I'm happy to talk to people, and yeah, hope everyone has a great afternoon.
Yeah. Thanks, Sarah.